Hi again, Attorney Steve Vondran, the business and real estate lawyer. We are talking in this video about Arizona Rules of Civil Procedure, Initial Disclosure Requirements, Rule 26.1. Without further ado, let's head to the Attorney Steve litigation whiteboard. Okay, let's back it up here. Actually, we're already backed up. We are talking in this rule about Arizona Rules of Civil Procedure 26.1. The initial disclosure requirement. Okay, so this is very simple. Okay, you file a lawsuit, the other party is going to do a responsive pleading, which is the answer. I file a lawsuit, you file the answer, or a demur. I file a counter complaint, you file an answer to that. So within 40 days of filing that initial complaint, let's say you have an answer, okay? Within 40 days of filing that answer, you have a voluntary disclosure statement that's due under Rule 26.1. Okay, so this is how it works. You have the document, the responsive pleading, 40 days, you answer. Okay, you not answer, you give your initial disclosure statement. Okay, this is a duty. This is unless the court orders otherwise. If you, for some reason, you go to court and you say we can't do that, or I can't do it within 40 days, this can be adjusted. It's a continuing duty until the case is over, so whenever you find new information you need to disclose that. Okay, so we've got that checked off, we've got that. Really, the last thing that we have here is what do we disclose? Okay, there's 9 things. Okay, so it's actually pretty simple. There's 9 things. 1, the factual basis. Set forth the facts of your case, what you know, what you believe to be true. Set forth the facts. Okay, the factual basis for your claims, factual basis for your defenses. 2, legal theories. Set forth your legal theories, what the law is. Cite some law, it's okay. Cite some case law in there and say this is what our theory is. The defendant breached the contract. They were supposed to sell the property, they didn't sell the property. You know, it was a slip and fall and they were injured in a swimming pool accident on this date. There was a duty of due care, those kinds of things. So legal theories, the number 2 thing. 3, you need to set forth all the witnesses that you're aware of. So if you know this person was a witness, maybe the escrow agent, let's say, was a witness to the breach of contract, you put down the name and the address, phone number, contact information for the escrow person. So you lay forth all the witnesses. Now, of course, you're not going to know everybody because there is a discovery process that goes through, but put down who you know. Put down the people that you know. And as I said, supplement that as new names become available. So your witnesses. 4, other persons with relevant knowledge. This may be people that you wouldn't necessarily call as a witness. You wouldn't put them on your witness list, number 3, but they may have some relevant knowledge, like the escrow agent. You may say, I'm not going to call the escrow agent into court, but we do believe they have some relevant information. So put down other persons with relevant knowledge pertaining to the case they have some knowledge pertaining to the case. The other side's entitled to know that and to try to get at that information. So what the courts are trying to do, what they try to do in Arizona, is to not have trial by ambush, to put all the cards on the table as early as possible. Okay, federal court has a very similar requirement. Note, however, that California does not have this early disclosure requirement. So it's kind of interesting, you know, being that our firm litigates business and real estate cases in both states, you know, we have firsthand, and in federal courts, we have firsthand knowledge of how this disclosure will work. So this is unique to Arizona. Federal courts also have a disclosure. California does not. Okay. Number 5, set forth all the persons who have given written or recorded statements. So if somebody was a police officer, came on the scene and they gave a police report and you're aware of that, put down what you know. Okay, disclose, initial disclosure. So put down what you know. Put that information out there. Okay. Number 6, expert witnesses. If you know you're going to have an appraiser that's going to come in as an expert, an accountant as an expert, a real estate broker standard of care expert, whatever you have, you know you're going to have some experts, if you know at the early stage, sometimes you don't know, the experts come later sometimes, but if you do know, disclose. Item number 6. Number 7, calculate your damages. If you're filing the complaint or a counter complaint, cross complaint, third party complaint, doesn't really matter. Calculate your damages, set forth what we're doing here. These are my damages. I've got this. I've got emotional damages. I've got lost business. I've got punitive damages. I have attorney fees. I have out-of-pocket costs. All kinds of things. So put down your damages. Itemize it to the extent that you're aware. Now these do not have to be cold, hard, solid, concrete facts. You can basically say this is what we believe. It's an approximation. It could be more. We're going, we reserve the right to supplement our disclosure at any time, or amend, supplement or amend. Okay, so your damages calculation, number 7. 8 is a list of documents and things that you plan to use at trial. Now again, it's early on in the litigation here because we're only within 40 days of a responsive pleading. So we're really kind of early in the first couple months of a case that we're doing these disclosures. But to the extent that evidence that's going to be used, the purchase and sale agreement, the escrow instructions, the disclosures, this is a real estate case, those kinds of things, we know these are going to be in itemize the evidence that you're going to use at trial. You may say, I'm going to use any pleadings that I get in discovery, any deposition transcripts that I get from the other party. So you're just putting a list of everything that you believe at this early stage that's going to be used. And finally, category number 9, any other persons with any other relevant evidence that you may be used, and who that person is, the custodian, the person who has those documents. So again, going back to our real estate example, you could have an escrow company and you say they have documents, the buyer has documents, this other party that made an offer on the property, they have documents, this real estate agent has documents. Okay, so you may want to put those up here with other persons with relevant knowledge. You may want to put them down here as well, other relevant evidence, and the custodian who has it. Okay, so these are the main things that you want to consider when you're doing your Arizona Rule 26.1 initial disclosure statement, State of Arizona. If you need help with a litigation case, you need a law firm to take it over. Lots of times we have judges that say, I've had enough of the pro per, you need to get a lawyer. You got a good case, but you're doing it wrong. I have to make you follow the rules of procedure. If you need some help, some advice, give us a call. You can find out more information at askattorneysteve.com. That'll take you to our homepage, askattorneysteve.com. Other than that, make sure you subscribe to our free legal updates right straight to your desktop. And we look forward to working with you. Thanks a lot. I hope this has been helpful.